There we go. Good afternoon.
Well, hello everybody, and welcome to this, the latest in Practico's Cost Chat Between Friends, in which we keep up with the latest developments in costs and review policy and the wider picture. The friends on this occasion are the usual: myself, Jeremy Morgan, retired cost silk and ongoing consultant to Practico, and the managing director of Practico, Andy Ellis. And the friend we've invited along today is Simon Teasdale, up and coming and highly successful young junior in 4 New Square, making a name for himself in the cost world. I say friends, in fact, this setup is the first time I've met Simon, because he actually came to the bar after I'd retired. But it shows that you can make friends, you can make new friends, as well as keeping in touch with old friends by listening to Practico's Costs podcasts. Today, you probably will not be surprised to know we're going to be talking about the Supreme Court decision handed down last week in the case of PACCAR, dealing with DBAs. And I will really say nothing more at this stage, but hand you over to Simon, who will give us an introduction into what they decided, and then we'll discuss the consequences for the wider world of that decision. Simon.
Thank you very much, and thank you both for having me on your podcast. I mean, yes, the big news in the cost world at the moment is definitely PACCAR, and in fact wider than the cost world. There's an awful lot of people paying attention to this space at the moment, and as you say, it's the well, somewhat bombshell decision last week of the Supreme Court that litigation funding agreements can amount to DBAs where the amount of the payment that the funder is going to receive under the agreement is to be determined by reference to the financial benefit obtained in the case, which, as we know, is almost all of them, basically. I hesitated slightly over the word bombshell, because although the impacts, which I'm sure we'll come on to talk about, will be seismic, anyone who was either at or was watching the hearing before the Supreme Court won't necessarily be too surprised, having seen the way the bench, or at least most of it, approached the issue. I'm conscious that avid listeners to your podcast series will already have some familiarity with the arguments that were in play in PACCAR, because back in April in your podcast there, Andrew Post took the listeners through those arguments. But it might just be helpful to have a bit of a brief refresher of the context, just to remember where we are with all this. So the central question was, of course, whether a litigation funding agreement, that is to say, we're really just thinking about third-party commercial funders rather than, say, solicitors funding a case through a classic DBA, whether a third-party funding agreement can constitute a damages-based agreement for the purposes of Section 58 AA of the Courts and Legal Services Act. And there are obviously some complexities and some nuances to that question, and the judgment runs to almost 100 pages, if ever there was an easy way of demonstrating that. And I would, for what it's worth, recommend reading it in full, because it is a helpful and useful judgment, both the majority's judgment and Lady Rose's dissenting judgment. But ultimately, it really boils down into what can seem like a fairly narrow point of statutory interpretation. We know, obviously, that the vast majority of funding agreements provide for the funder receiving an amount in return, which is determined by reference to the amount of the financial benefit obtained. Usually it's just simply by reference to a percentage of the damages recovered by the claimant. Yes, you will often see in waterfalls different ways in which the funder can get paid, and they might be cumulative. You might get multiples of investments on top of a percentage of damages. It might be one or the other, but usually there is going to be something in there that provides, at least in some circumstances, for payment by reference to a proportion of the sums recovered. So in that sense, they look a bit like DBAs. But in order to be a DBA for the purposes of Section 58 AA, the agreement in question needs to be one between, on the one hand, a person who is providing advocacy services, litigation services, or claims management services, and the recipient of those services on the other hand. Now, ordinary funding agreements are not going to fall into the first two categories. They're not going to be with someone who's providing advocacy services or litigation services. So the question is, do these funding agreements fall within the scope of providing claims management services? And on the face of it, just looking at that phrase, you might think, well, no. I mean, funders won't usually be actively managing the claim. Or at least even if you take a cynical view, they won't be doing so through some strict contractual entitlement. I mean, the soft power of holding the purse strings can go a long way, but they won't be doing it through a contractual right. And so you might think, well, that's all very straightforward. They're not managing the claims, so it can't be claims management services, job done. But there is a fairly short route to the contrary view, and it's the analysis which the majority in the Supreme Court adopted in PACCAR. And it goes something like this. I mean, step one, the meaning of claims management services for the purposes of that section, section 58AA, is stated to be the same as the meaning used in the separate primary legislation that regulates claims management services or gives the powers to regulate claims management services. Now, that used to be the Compensation Act 2006. It's now the Financial Services and Markets Act 2000 in a slightly confusing reverse chronological move. But in any event, both of them basically say the same thing about the definition of claims management services. They say that it means advice or other services in relation to the making of the claim. And they say that other services in that phrase includes financial services or assistance. So by that relatively short route, the Supreme Court say and concluded that litigation funders are providing financial services or financial assistance in relation to the making of the claim. Therefore, they are providing claims management services as defined in those separate bits of primary legislation. Therefore, they must also be providing claims management services under Section 58AA, and they're capable of being damages-based agreements when, as we know they always do, they provide for the relevant kind of payment based on the financial benefit obtained by the claimant. Now, Jeremy, I think you noted in the previous podcast, it's fair to say that this argument has been floating around for a while. But equally, I think it's fair to say that the general consensus in the industry had been, for now some time, that litigation funding agreements were not DBAs within this section. I mean, of course, it's always worth remembering that there's an often forgotten about provision, Section 58B in the Courts and Legal Services Act, that was enacted specifically to be there to enable regulation of funders directly. It's often forgotten about because it hasn't ever been brought into force. But one might think that it would be relevant to interpreting the scope of its sister provisions, Section 58 and Section 58AA, dealing with CFAs and DBAs. And Lady Rose, in her dissenting judgment, did take the view that the courts below had been correct, that litigation funding agreements were not caught by Section 58AA. And it's probably worth touching upon the sort of three short reasons for that. First of all, her view was that just because claims management services can include the provision of financial services in relation to the making of a claim, that doesn't mean that every instance of providing financial services in relation to a claim will be a claims management service. In her view, there must still be some recognizable sense in which a claims management service is being provided. That was referred to in the judgment a lot as the potency of the term defined. But my less clever way of saying would be the relevance of the label, in a sense that the label isn't entirely abandoned just because there's some more specific definition. The second point that I think she relied on quite importantly was that she looked to the 2010 and 2013 DBA regulations as an aid to the construction and concluded that it was quite apparent that those were not directed at agreements with litigation funders. I mean, all of the language in those regulations are about the language of clients and representatives. It's the language of payment for the work done by the representative. It's the language of expenses by reference to disbursements and counsels fees. Just not apt really to deal with third-party litigation funders. And I think thirdly, and perhaps most importantly, she concluded that it was obviously improbable that Parliament would have intended, sort of quietly and opaquely, to, on the one hand, enact Section 58B with a view to directly regulating litigation funding agreements, only to sort of indirectly bring them within Section 58AA and render almost all of them unenforceable in the form that we all know they traditionally take. And for my part, you know, I think that Lady Rose's dissenting judgment contains some pretty powerful and convincing reasoning, but the rest of the Supreme Court were firmly on the side of the appellant, much as was clear in the room, to be honest. And you know, we'll come on to talking about the pretty major impacts that this is going to have on the industry and on the sort of claims that it's going to no doubt bring about. But before we do, it might be worth just briefly touching on, I think that the Supreme Court's judgment serves as actually quite an important reminder of a few key points about statutory interpretation that are relevant not just to this litigation funding context, but so many arguments that we have in this world of costs, whether it's in the world of CFAs, you know, QOCs, you know, all these sorts of areas that are very heavily controlled by Parliament. The first is, I think, a reminder about labels, because the majority in the Supreme Court were really just not particularly worried about the idea that litigation funders don't, on their face, you know, seem to be providing what we would naturally call claims management services. The difficulty that they saw, in contrast to Lady Rose, the difficulty they saw was that they perceived there's been just no real consensus about what claims management services means. And they just thought that, well, in the absence of any real consensus about what those words mean on their own, how can it displace a fairly clear, in natural meaning, definition that's been supplied by Parliament? And that scenario obviously comes up quite a lot. You know, we are so frequently in a scenario where, you know, you're saying to a court, you're looking at a word or a phrase in a statute or the rules, and you say, well, I can't give you a comprehensive explanation of everything that will always fall within this phrase, but I can tell you what definitely sits outside of it. That's a pretty familiar place that we all find ourselves in. And I think the Supreme Court's decision is a real reminder to be cautious about relying too much on labels, where you can't supply a very clear, hard and fast sort of natural meaning consensus on what those words mean. It was very slightly reminiscent of the sort of debate in Bellsner about these labels of contentious and non-contentious costs, and everyone getting very excited, or at least one member of the bench getting very excited about, oh, well, doesn't it seem crazy that all this pre-action space is considered non-contentious? Well, there is a real risk of reading too much into labels when statute perhaps provides the easiest answer. The second reminder is about chronology in these statutory instruments, because there was a big argument in PACCAR about whether it was appropriate to take into account later legislation as an aid to construing the meanings of words in earlier legislation, particularly things like the DBA regs, in order to interpret the phrase claims management services. Now, I'm going to avoid getting into going down the rabbit hole at the very least of talking about when it is or isn't appropriate to do that, particularly when you're in the territory of subordinate legislation. But the important thing is that it's really easy to forget that there are really important limits on how much you can rely safely on later legislation to construe earlier legislation. And I think in the world of things like QOCs and CFAs, where you've got different legislative schemes that to an extent interlock but are fundamentally separate, we are often in the cost world at risk of forgetting this principle, because we like to think that all of Parliament's acts are part of some grand omniscient plan that will all fit neatly into one. But sadly, it's not always the case, and you do need to remember the chronology of these statutory instruments. And then just finally, I think it's a reminder of the limits of purposive interpretations and what they call the rule against absurdity. I suspect those will be some of the most controversial parts of the majority's judgment in PACCAR. But whatever the rights and wrongs of the analysis, it's at least a reminder, and a helpful and important reminder, that the court's always going to start with the question of, well, how sure are they on the natural and ordinary meanings of the words, that they know what Parliament intended to say? And usually a purposive interpretation is only going to help you where the court perceives there to be some ambiguity in the language itself. If the court's dead against you and says there's no ambiguity, they're going to be slow to start using purposive interpretations to bend those words. And even the rule against absurdity, in the majority's judgment, we were reminded that it won't usually be seen as an opportunity to rewrite the statute or enable the court to substitute its own view on what should have been said. And I think there's actually been quite a bit of that from the Supreme Court recently. I mean, just thinking back to things like Ho and Adelaken, arguments about policy and trying to read the rules in light of some grander policy objective or where it must all have gone. The Supreme Court was pretty hesitant about that in Ho and Adelaken, and I think it's beginning a bit of a trend, which is a little bit concerning for reasons we might come on to, because we really do not want necessarily a Supreme Court that purely is looking at the words on the page and saying, well, look, it's for Parliament to change things if they need to, only because we all know how difficult it is to get anything under the nose of the legislature these days, and the prospect of things changing quickly is difficult. So I think those are three really important reminders. And just finally on that point, I mean, the majority of the Supreme Court really didn't seem particularly concerned about the impacts that are going to come about from this decision. I mean, they acknowledged them. They acknowledged that their decision was likely to mean that the vast majority of funding agreements were unenforceable. But they didn't seem particularly concerned about that. I mean, you'll have seen the hearing, and at the end of the hearing, the panel did seem concerned about it. I mean, they were talking in terms of, well, if we're against you, does this need primary legislation? Will it need secondary legislation? And whilst I was pessimistic that the decision would go this way, I did think it would end with some sort of paragraph or two saying, look, this needs to be reviewed urgently. The MOJ needs to look at this. If it's what everyone intended, then fine, but double check. And you do get that in decisions where the Supreme Court feels their hands are tied. They often just try and nudge it to someone's attention, but there didn't really seem to be much of that in this case. And I found that pretty surprising. I mean, as I say, this is probably going to need primary legislation to fix, if it is going to be fixed. I don't know when that is realistically going to happen, and who knows what damage will be done in the meantime.
Can I just come in on the approach to statutory interpretation? I completely agree with the conclusions that you draw, Simon, but I did notice a massive difference in the approach of Lady Rose and the others, and in a way hers was very much more reassuring, regardless of the outcome. Just the way she structured her judgment and followed through the argument was very concerned to establish what the real world involved, and what the impact of whatever decision they made would have on that real world. Not simply by quoting from the witness statements. I think probably both sides did that. She certainly did it a bit more. But it was very clear to her that there was a problem here. And to be honest, reading the Supreme Court's, the majority's judgment, you wouldn't really think there was an academic problem there to be solved in an ivory tower by reading the words of the statute. And one completely see why, looking just at the words of the statute, they came to the conclusion that they did. But there seems to be, as you say, very little acknowledgement of the problems that this very dry legalistic approach causes. And I think that is a problem. And there is something to be said with the argument that cases of any importance, certainly in the world of costs, shouldn't go near the Supreme Court, because from time to time, when they do get near them, they make a bit of a pig's ear. But before you were in practice, there was the case of Callaway Gray, where absolutely critical case on CFAs, right at the beginning of CFAs coming into existence. Court of Appeal said, oh, it's an important matter, must go to the House of Lords, and it still was in those days. The House of Lords just said, well, we don't really know what to do about this sort of thing. It's not for the likes of us. And kind of stepped back from it. There's quite a lot to be said for that, because they do quite often have strong feelings about things. And having a strong feeling about what is the just outcome is quite important in getting to the conclusion. I think you could say they weren't really, in the language of the judgment, put it that way, they don't appear to have been that concerned. And yet it is a bombshell.
Well, I agree. And without wanting to be sort of too high-minded about all this, I think there's an element of asking yourself what is the court for? Whether it's the county court, the Court of Appeal, the Supreme Court. I mean, surely, yes, you want the courts to follow principles and not to be just purely driven by getting to any outcome they want by whatever means. Although that does happen plenty frequently. But you fundamentally, particularly the highest courts and the appellate courts, you want there to be some degree of aiming for a just outcome that works and obtains policy objectives and fits in the real world. Because to an extent, the courts perform a very useful function in taking the words on the page that Parliament have provided for in something of a vacuum and applying that into the real world. And there is a danger that if the courts approach that task too narrowly, as almost, as you say, a sort of pure academic exercise, you risk there being a bit of a gap, because who is going to make those sort of principles and those words on the page fit the real world? Because if it's just, well, they don't fit at the moment, refer them back, it relies on some conception of the legislature having a constant eye on every area and a constant capacity to make small adjustments that it just doesn't have. And it also isn't particularly well placed to do either. So it is concerning. And look, don't intend to be disparaging in any way of a panel of bigger brains than me, but there is some people would look at this and say there is a losing sight of the wood for the trees here, getting very, very excited about the minutiae. And we can all see the logic of it. We can all see the logic of how those words on a page lead you to the conclusion that the providing of financial services, claims management, you plug it into Section 58A and you get there. But there's more to it than that, surely. And I do think that Lady Rose's approach has an awful lot more to commend it. But there we go.
Just to come back on one thing in relation to the real world, one of the things the majority said was, well, the term claims management services doesn't really mean anything very much by itself. We're not quite sure what it's supposed to mean. If you go back to 2006, when the Compensation Act was passed, and that's where the words "after all" come from, we were not long after the major scandals of Claims Direct and the Accident Group. People were already complaining, and there've been investigations into at a policy level. These people were complaining about all the phone calls they were getting about the accident they hadn't had, and the selling of insurance to people through thoroughly, underhand means. I don't think back in 2006, there were many people, at least who lived in the real world, who would not have known broadly what was meant by offering claims management services. They were pretty standard. God, you and I, or rather Andy and I, certainly became involved with a lot of them, and the approach was reasonably similar. In terms of sheer language, it's true. It's hard to get a lot out of that phrase because it doesn't go back, generations. But certainly, as an expression used in legislation at that time, I think it was pretty clear what it meant.
But I agree. And I mean, I think on that point, it's also a quirk of the way in which the language of claims management services is used in that part of the Compensation Act and FSMA. Because, I mean, it sort of goes back to this point of being able to point to things that definitely aren't, and being able to point to most of the things that are, but acknowledging that there might be a grey area. The problem was, as came up in PACCAR, the way that the definition was used in those bits of primary legislation, that they were able to say, well, it makes sense for this definition to be very, very broad, because it's not actually defining the services that will be and are regulated. It's defining the group of services that can be regulated and are on the table. And why would Parliament have kept that tightly controlled? They would want to give as much scope as possible for all such services to be regulated. And so I think there's also, you can just imagine how these things unfortunately come about without people having necessarily thought about them. When someone's scratching around for a definition of claims management services to plug into section 58AA, they go, oh great, well we've got one over there. Not thinking about, well, actually in that context, in that act, it's being used in a way that might be construed broadly, and do we necessarily want a broad... The people drafting these documents are not superhuman. And there is a danger sometimes of ascribing, I think, or assuming that more thought has gone into some of these things at the drafting stage than there has been. And I think that's dangerous. Yeah,
I completely agree. Anyway, consequences. What can be done and what's going to happen?
Well, I mean, off to the races, I think. I think there's an important split here. There's a split between what's going on and what will go on with sort of ongoing and future cases on the one hand, and what's going to happen with cases that are either about to finish or have finished. I think the reason for splitting those out and considering them separately is that where you've got ongoing or future cases, the parties, by which I mean the person providing the funding and the person receiving the funding, have good reason to cooperate to find a solution to all this. That they both have an interest in the relationship working. And so for those parties, there is going to be time pressure, and there is going to be stress, and there are going to be compromises. But fundamentally, the question for them is, what funding mechanisms, what structures remain available? There will still be ways for funders to fund litigation. All is certainly not lost. But the difficulty, certainly in the near term, is going to come in trying to achieve something that is commercially similar to what went before. I think either expectations are going to need to be lowered, whether that's on a client side or a funding side, or drafters are going to need to get inventive, which of course brings risk, and we'll all be back here again in 2 years' time talking about what went right or wrong in the case about those risky alternatives. I mean, obviously there are some very vanilla things that you can see, that you can envisage might well escape PACCAR. So for example, funding where the return is simply multiples or fixed multiples of the investment. But the problem with that is it's just not going to be as commercially flexible as the sort of funding agreements you see at the moment. I mean, if it really is as basic as 3x, 4x, 5x return on the funding based on the risk involved, those agreements will obviously be worse for consumers if the recovery is low, and because they will be paying probably a relatively high multiple, and worse for funders if the return is high, because they'll probably have left some money on the table that they would have got if they were taking a percentage of the proceeds. And as soon as you try and tailor the way those multiples connect to the recovery in the case, you get more into this dance that we are going to see with the language of section 58AA, and how close you go to the line of your payment as a funder being referable to the amount recovered. But whatever happens, it's not going to help consumers, because all of these agreements are going to either be very much more basic and therefore a bit more crude and less useful to people, or they're going to be complex and novel, which never helps people to understand them. And I think that there is going to be a period of people finding out what does and doesn't work. I mean, the focus is understandably on these ongoing cases because they are the most sort of immediate issue for everyone to look at. And I mean, obviously, certainly for opt-out proceedings, there is going to be a big reckoning and a big rethink about how they're funded and how they work. But at least that will play out somewhat publicly, and probably quite quickly, such that I would hope within 6 months, 9 months, we get to a place where there starts to be some degree of clarity and consensus on some of the alternative structures that are available. But over the next few years, for my part, I think the much bigger problem, it isn't going to be fixing these ongoing and future cases. It's going to be how we all deal with the cases which have concluded or are about to. Because those are the cases where the clients and the funders don't necessarily have reasons to work together. The pros and cons of this deal will start to be clear. I mean, where the money has already gone to the funder, you will obviously have clients taking advice on whether or not this decision gives them a route to claiming back monies that were paid under those agreements, either directly from the funder, or perhaps some sort of claim against their solicitors in relation to the advice they received about the funding agreement. Or perhaps even more stressful and worrying for solicitors is, I can see a world in which, if you imagine you've got a claim finishing in the next couple of months, the damages are received into the solicitor's client account, and the client says to the solicitor, I know there is this big tripartite funding agreement with a waterfall that tells you exactly how you're going to pay those monies out, and I know that I look like I've agreed to that, but don't you dare send that money to the funder because I'm challenging the enforcement of that agreement. And you then have this solicitor trapped in the middle of a client that perhaps they're also asking to pay their fees and they want to keep a relationship with on the one hand, and they've got the funder on the other hand bearing down on the solicitor saying, what on earth are you doing? I've demanded the payment that I'm entitled under this funding agreement. And the solicitor may well be trapped in the middle, fighting on two sides and finding themselves in real difficulty, because the reality is we can all, and I'm sure we all do, have views on how this might go and what arguments might be deployed, but not a sane person on planet Earth will tell you that any of this is a slam dunk one way or the other. It's complicated. And we are going to have some big cases, and there will be some unfortunate people and firms and funders who will be the one who gets picked to fight this out first in front of the courts, and it is going to be very high stakes. And we are going to get into the territory of, I think, two big issues. Number one, to what extent can the unenforceable parts of a litigation funding agreement be severed from an agreement that might provide alternative mechanisms for getting paid that are unobjectionable? That will be one big fight. And the second will be, to what extent can a client demand repayment of sums which have been paid under an unenforceable DBA? And just on that point, one thing to flag, case of Diag Human and Volterra Fietta, a case that Nick Bacon and I have been involved in recently, was heard in the Court of Appeal earlier this month. I can't say too much about it because the court's heard argument and are deliberating at the moment. I'm sure we'll have their reserved judgment in due course. But what I can say is that it's a case in which the Court of Appeal has had to consider these sorts of issues in the context of what is essentially a discounted CFA. And the two questions, really important questions for the Court of Appeal in that case, are: can the unenforceable conditional parts of a CFA be severed from the unconditional parts where there's provision for paying some monies win or lose? And if not, and the retainer remains unenforceable, can the client obtain repayment of the sums paid to date? Now, obviously there are some important differences between the world of CFAs and DBAs and LFAs. But when we get the Court of Appeal's judgment, people will need to keep an eye out for it, because it will be important reading for anyone who's about to start launching into arguments about severance, etc. in this context. And the other important case that everyone will already have on their radar, but will have a renewed importance, is the Zuberi and Lexlaw case. It was flagged in PACCAR, of course. Two important things there. One, the availability of severance was touched upon briefly, but they hadn't had proper argument on whether severance could be the answer in Zuberi. So although it was touched upon, there wasn't a firm decision, but that will come back up. But also we'll be back into this question of what is the DBA, because obviously it was Coulson and Lewison in Zuberi both approached the question by reference to what is the DBA. Newey approached it slightly differently. But that question of what is the DBA, what is Section 58AA aimed at, is it the whole of the agreement, or is it just the bit that provides for payment by reference to the outcome of the case? That question will probably be relevant to the policy issues that will be engaged whenever someone's trying to sever. So we are going to be right back into that territory, and I would have thought that whoever is sort of picked to go first, as it were, will be straight to the Court of Appeal very quickly on these issues, and these will be much harder issues to solve between the parties than the ongoing and future cases. So I think there is going to be years of disputes about this, to be honest.
The other thing which I think Lady Rose picked on was the impact on collective agreements, collective litigation, which is obviously very important because they're completely dependent upon DBAs for a great part of them. Is that going to be able to survive, do you think? Do you think the litigation funders will come up with acceptable means of funding such litigation?
That's actually, but this is the thing. This is a perfect example of these collective proceedings. In the one sense, they are the area of the most obvious and extreme impact and the most immediate concern, because the millisecond the judgment came out, everyone involved in those cases immediately had to turn their minds to this and finding a solution. And the day after PACCAR, it's probably the position where the solution is least easy to identify. But there are so many interests, minds, resources being ploughed into finding solutions that I've got no doubt that there will be solutions. It may well be that some of the solutions people are running with now don't end up being the thing that works in 2, 3, 4 years' time, and there will be all sorts of CPO hearings and disputes that I'm sure will be referred up quite quickly. And I'm sure that there will be some hurdles on the way, but they will find a way. I'm sure that they will find a way to keep those going because it's so important. Judges will be bending over backwards to find ways to make those proceedings work, I think. And they're also of a scale where I can see there being commercial scope for doing some agreements that will work. I think those will survive. I'm much more optimistic about that than the people who might lose out one way or the other because they've got an agreement that is in the past and unenforceable and no longer fixable.
Well, one of the problems, of course, of looking at a consensus, say, well, a consensus will emerge, is that there has been effectively a consensus because there weren't very many dissenting voices since DBAs first came into force, that possibly litigation funding agreements were caught. And everyone said, oh, no, that can't be what they meant. Oh, no, it'll be all right, and so on. But there was a reluctance for that and for other reasons for some years for DBAs to get off the ground. Yeah. And then just as soon as they get off the ground, litigation funders take this hit. So it's a difficult world, particularly if the courts want to find a solution. Does the Supreme Court really care?
Well, no, maybe the Supreme Court doesn't. But I think, Jeremy, this is a really good point because this is one of the issues that plagued DBAs. But of course, the other one was the universe of termination provisions and the extent to which people could get paid in the event their client terminated. And when you look at that, when you look at Zuberi, you see the total other side of the coin, right? Because in that world, the Court of Appeal got hold of this issue. They probably saw that the MOJ had failed to advance the draft 2019 regulations that would have solved this issue quite neatly and easily. Those have been put on a shelf and forgotten about. And so I think in that case, the Court of Appeal looked at this, took a pragmatic view and said, what's going on here? Are we seriously going to uphold an interpretation that makes DBAs just unusable for solicitors? Or just insanely risky? No, we'll find a way around it. And so I think that the Zuberi case should give reassurance that courts, including the Court of Appeal, will in many cases really strive to make these regimes workable.
I agree. I'd have much more faith in the Court of Appeal or the divisional court in PACCAR doing effectively the same thing. Of trying to get a solution. But then you do have a problem when you read Zuberi and you see the really radically different approaches of Lewis and Newey to reach the practical solution, but through very, very different means. And then Coulson managed to agree with both of them.
And actually, we talked a moment ago about the 2019 regulations. I mean, this whole episode is another reminder of how unfortunate it is that hard work of Rachel Mulholland and Nick Bacon was put on a shelf, because of course it might have also helped with PACCAR. In the first regulation of the draft 2019 regulations, there was a sub-paragraph that sought to clear up this idea of litigation funding agreements falling within the EBA provisions, supplemented by, if you remember, the draft explanatory memorandum, where they said, no doubt, pushing their own agenda, that it was made clear in the explanatory memorandum that some of the language used in the 2019 draft regs was there precisely because it wasn't intended for third-party funding agreements to be caught within Section 58AA. Now, actually, query whether that would, on the majority of the Supreme Court's analysis, have saved the day here. But it might have been yet another nudge to the majority that they were heading in the wrong direction. And so this whole thing is a reminder that whilst Zuberi found a way around one thing that project sought to do, it's very unfortunate it was put on the shelf, because it might also have helped with this, and we might have not been in the situation we're in today.
You've hinted at this already, but okay, so the courts are going to be grappling with lots of arguments that at the moment, lots and lots of solicitors and barristers are busy trying to work out. That can take some time and will lead to some considerable period of uncertainty involving very large sums of money sometimes. So that's a real problem. Can we count on the Ministry of Justice coming up with a snappy solution to all of this?
No, I just don't think so. As you say, Jeremy, I haven't been on as many terms around the block as you have, but I am certainly yet to see a scenario in which the MOJ rapidly responds with a perfectly honed and directed amendment that solves a practical problem. It's interesting. I was looking back at the podcast you had with Andrew Post, and this question of, well, is the government incentivized to do anything about this? I mean, certainly the current government has no great affection for litigation being brought against it, and perhaps the world of litigation funding falling away wouldn't be the worst thing in the world. But there's a lot of money involved here, and there is a broader point in that there is a risk in all this, that this sort of global Britain, London as a hub of international litigation, which everyone on all sides is usually so proud of, that is getting chipped away at here. And I'm not saying doom and gloom, people are going to move their cases elsewhere, because there's all sorts of brilliant reasons why international litigation comes to London. But I mean, going back to, without talking specifically about the Voltaire Fiat case, but I mean that case in the first instance decisions, I know anecdotally that loads of other firms who operate in that sort of international arbitration market, saw these decisions of the English courts and these sort of old-fashioned concepts of champati and the steep cliff edge that you seem to fall off if you tiptoe outside the remit of the Courts and Legal Services Act. And it was just so alien to them, being familiar with much more permissive jurisdictions elsewhere. And it struck them as such an unjust and sort of high-risk outcome that there's a nervousness. I mean, particularly in the world of arbitration, where you've got a bit more opportunity to pick and choose where you are, there's a nervousness in the market generally about having those sorts of retainers governed by English law. There's a nervousness about having your arbitration seated in London. People are desperate to avoid the commercial viability of running a case be ruined by what they see as some fairly old-fashioned and immovable rules in play in England. And if you layer on top of that, not just that lawyers have to be very careful about their agreements, but on top of that the commercial funders footing the bill need to be extremely careful about their agreements, there is a risk that we make it less attractive. And actually, Jeremy, not picking up on a point you just made, it's even worse than that, because funders will say, well, we were being careful. We were spending thousands of pounds getting the best advice and drafting these agreements. And everyone did say that this would be fine, or or gave reassuring comments to that effect. And we've ended up a decade down the line with PACCAR and all these risks and worries. Why am I going to allocate my capital somewhere where in 5 years' time some other decision might come out and suddenly I'm having to deal with people coming and knocking at my door again? You don't even have to be on the wrong side of these things. Just see these risks as making allocating capital to this jurisdiction less attractive. And I don't want to be doom and gloom. It's not in any way going to be the end of the London litigation market, thank God. But these broader picture, we can't lose sight of it, because the courts will always have their eye on the law and making sure they are the defenders of certain interests other than others. But at the end of the day, we want a system that works, and we want to keep it attractive to the users.
I suppose, speaking from the other side of the channel, I do recall, it was only a couple of years ago, I think it was the European Parliament produced a paper which was highly critical of litigation funding in the UK, on the basis that compared with the equivalents operating in Europe, the funders were taking a much greater chunk of the proceeds, and that was it was criticised in fairly robust terms. I think possibly on the initiative of a single Euro MP who had to be in his bonnet about it as a German lawyer, but I might be remembering it wrong there.
No, I think you're right. I think you're right. But I suppose the difference there is, I actually don't think that many people would be against refining the way this industry is regulated, particularly if it came with the quid pro quo of reducing the risks if you tiptoe outside that world. Because the problem in this arena is it's all such high stakes. There is this understandable perception that the punishment rarely fits the crime. If you step across the line in any of these areas, whether it's CFAs, DBAs, litigation funding agreements, whatever, the danger is not that you take a bit of a penalty, or someone works out if there's been some prejudice or whatever. The danger is you completely fall off a cliff and you're told that nothing's recoverable. So I actually think that the problem comes, it may well be that we need better regulation or whatever it is, but the problem is the downside risks. It's the 1 in 100 case where there's a disaster. That's the thing that is going to be the disincentive. Well,
one technical thought I had was this, which is I was always, when I was on the Jackson committee as one of his assessors, a strong proponent of getting rid of the indemnity principle. It seemed to me the cause of huge numbers of arguments and a great deal of injustice. But thinking about it in this context, actually it wouldn't have made any difference at all in this case, because this isn't an indemnity principle case. It's a case about the funding necessary to get your collective proceedings off the ground.
I agree. And although interestingly, Jeremy, funny you say that, again, without naming any cases, in every case that is ongoing at the moment, someone is trying to find a way to make PACCAR relevant to their own benefit. And umpteen arguments are coming out of the woodwork, and some of them are quite interesting. But one that at the moment I'm not convinced about is I have seen it crop up. People taking arguments about, well, if the reality is that the funder was always going to be funding the costs, and the funding agreement's unenforceable, then breach of indemnity principle, we don't have to pay you any costs, and any cost orders we've paid you to date are gone. I mean, I don't see how that gets off the ground, precisely because we've already had all those wars about the insured party and whether or not they really do have a notional liability to pay the cost. Maybe that's all basically done and dusted, and people are usually, with a few minor exceptions, so careful to make sure that any funding agreement they enter into, and retainers, crucially, that they enter into, retains some sliver of a notional liability on the client to make sure you don't fall foul of the indemnity principle. That, frankly, of course, you should all remember, if that sliver isn't there, it's a problem whether your litigation funding agreement's enforceable or not, because the point is always, does the client have the liability? So I agree. I mean, I think the indemnity principle in many cases is at times a bit of a fiction. I mean, the world of CFA lights being the obvious example. But yeah, no, I don't think actually it would make a huge amount of difference to this scenario.
Andy, you're a punter out there in the real world. What do you say about all of this?
Well, thank you. First of all, thank you very much for that discussion, which was absolutely fascinating, and well, I would recommend that people listen to this podcast anyway, wouldn't I? But I enjoyed listening to that discussion, and I learned a lot. In terms of the impact, which I suppose is what we're really concerned with, now I'm principally concerned with, I suppose, is I suppose there's going to be a shifting of resource towards, check my funding agreement
Well, exactly.
that sort of thing, and that, in terms of the corporate world, which is facing an increasing number of funded claims, and particularly in collective actions, that I can see why they would want to see, as part of a delay strategy, the revisitation of certification, and fight a lot harder in relation to certification of cases that come before the courts in relation to opt-out and so on and so forth. But just generally, I think that we know from the history of it so far that DBA it's a very, very fragile ecosystem, and it always was. And just when you think you're getting over it, to have an argument that could have been run 10 years ago, and has taken all this time to come, is really unfortunate. But it is what it is, and I suppose I hold out some sort of hope, but it's really a slither, that the reviews of the current Minister of Justice are that he's a proper lawyer who understands the issues, and that could not be said of many of his predecessors.
Well, more than that, he was a pupil of Andrew Post, which I think Andrew said on air. I can't remember.
He did, indeed. He said it chalk, yeah. But you tell me, how many months there are to go towards the general election. The idea of any of this being on anybody's priority is absolutely nil, isn't it?
Yeah,
absolutely nil. So therefore, perhaps the solutions will have to come elsewhere. And I just tend to agree that this is going to be disruptive. It's going to be the cause of delays. A lot of it seems to be unnecessary and somewhat unfortunate. And I just join in with you, saying, I wish they'd gone on with regulation. I don't pretend to know why Section 58B wasn't brought into force. I don't know, whether that would have helped or not. Who cares now? We have a Supreme Court decision, and we've got to look we've got to look on the other side of it. But likewise, I do think that there's an element of shooting ourselves in the feet, as you were talking about, in terms of attracting global or international litigation to this jurisdiction. It seems to me to be unnecessary. People not seeing the big picture, and I think in terms of concerns about funding agreements and whether they're fair, or whether they're properly regulated, or whether they're too greedy, or whatever they are. That there's a different way to solve that. And just calling a halt on things doesn't solve it at all. So that's my comment on it. Bit glum.
Yeah,
it's
raining as well, so that's probably one of the reasons.
Well, look, Simon, and thanks for that, Andy, and Simon, thank you very much. Those who are watching might be interested to know that we prepared the agenda for this talk a couple of weeks ago, and it consisted of PACCAR, which we knew was going to be handed down, Volterra, Zuberi, and the Nick and Rachel draft regulations. And Simon, you managed to get the whole lot in under the single heading of PACCAR. So congratulations. And thank you so much. It's been really interesting.
No, not at all. I've really enjoyed it. Thank you for having me.
Okay, thank you.